I join the distinguished leader of the Committee on Health, Education, Labor, and Welfare in opposing Senate Joint Resolution 36 and to support the National Labor Relations Board rule that would very simply modernize the process that workers use to decide whether they want to form a union. And right from the start, let's be very clear about what is at stake here. It is a rule that the National Labor Relations Board has formulated pursuant to the Administrative Procedure Act set by the Congress of the United States after comment that was solicited from all the relevant stakeholders and people who would be affected by it. And they are rules that are long overdue because of the inconsistency and delays that are endemic to the current process. As I travel around the state of Connecticut and I hear from people around the country, I consistently hear about problems that exist under the present process for choosing a union. This rule does not determine the outcome. It simply modernizes and improves the process, and it does it by a rulemaking process that is consistent with and pursuant to the Administrative Procedure Act, which is the way that the Congress has said it should be done. And in fact, it adopts the rulemaking procedure rather than doing it by individual cases, which is the way that the United States Supreme Court and the Courts of Appeals have said to the board it should do more often. So far from raising constitutional questions or issues of procedural lack of process, the NLRB has acted in accordance with the will of the Congress and the Constitution in formulating this rule. Why is it necessary? Well, for one thing, there are 34 regional offices of the National Labor Relations Board, and each of them has different policies and practices for processing election petitions. We're talking about petitions that are submitted by workers who want to form a union and can do so by election when at least 30% of those employees send the petition to the NLRB. The gap in time is an opportunity for intimidation by unscrupulous employers. Fortunately, they are a minority, small minority of employers, but they exist, that wish to discourage or deter workers from forming a union. That intimidation is unacceptable. We should do everything we can to stop it. Second, the delays themselves are intolerable. Some of those delays are years, as long as 13 years in some instances. And the gap in time discourages or deters the exercise of rights that are guaranteed under the law. So this new rule is simply to modernize the process, end intimidation, make sure that rights are made real in real time so that employees can exercise those rights without any discouragement from employers. Are the employers free to communicate with workers? Of course they are. The rights of communication on the part of the employers are not eliminated by any means. Are they still part of the process? Yes, indeed, employers remain part of the process if they wish to do. The effort here, as one of the employers, in fact, that submitted comments to the NLRB said, quite pointedly, Healthcare West, a healthcare company with 31,000 employees, in its comments said, quote, reforms proposed by the NLRB are not pro-union or pro-business, they are pro-modernization, end quote, and will, quote, modernize the representation election process by improving the board's current representation election procedures that result in unnecessary delays, allow unnecessary litigation, and fail to take advantage of modern communication technologies. That quote from an employer really says it all. Some of the litigation is not only against the interests of employees, it also is costly to the employers, especially when it fails to succeed. It creates uncertainties for other employers, and it can block representation and lead, again, to unnecessary delays. This rule has an impact on real people in Connecticut and around the country. To give you a couple of examples, registered nurses who are at a number of the hospitals in Connecticut have come to me about the need to reform this process. Members of the employee workforce at T-Mobile, for example, and Chris Koza, a technician at T-Mobile USA in Connecticut, joined with 14 colleagues, came to me to recount his experience. He filed for union representation with the support of the Communications Workers of America, the CWA. He experienced problems of exactly this kind because his rights were delayed and thereby almost denied. And when T-Mobile USA filed a claim that officially challenged the status of CWA as a labor organization, he could see, Chris Koza and all of us could see, that clearly CWA is a labor organization. This tactic was simply a delaying one, and the NLRB rule would prevent the kind of frivolous challenges and frivolous litigation that occurred there. Mr. President, let me conclude by saying that, as has been said already, this rule is neither pro-union nor pro-employer. It is simply pro-fairness. It is anti-delay, anti-frivolous litigation, and it is pro-fairness in the workplace.